Your Honor, at 1:17 p.m. on the date in question, the fire department responded to 614 Mays Street for a fire in a house. Crews arrived to find dense black smoke issuing from the eaves and roof vents of the home. They made entry with a hose line into zero visibility conditions in the living room to find fire in the area of the television. The remainder of the home had light smoke conditions with good visibility throughout. During the fire attack, the homeowner and family had returned from a trip to the store. Shortly afterwards, the fire was declared under control. While fire crews were gathering information and the hose was being reloaded, another fire 3 blocks away was being dispatched. This fire had a report of children trapped inside. Considering the gravity of the situation, all of the fire crews which operate at 614 Mays Street responded to the fire with rescue. No fire personnel were left at 614 Mays Street since all available firefighters would be required to control the other fire and rescue the children. We feel it is safe to say that based on what was known of the facts at the Mays Street fire prior to an investigation, no reasonable firefighter would have remained at that scene knowing children were in danger just 3 blocks away. We feel that evidence should be admitted and shown to the jury based on the fire investigators' presence being a continuation of the initial fire crews. We believe the time lapse between the fire crews leaving the scene to respond to the nearby fire with report of children trapped and the arrival of the fire investigator can be deemed reasonable and no violation of the homeowner's Fourth Amendment rights occurred. In Michigan versus Tyler, the fire was declared under control at 4 a.m. Due to the darkness, a more thorough investigation was conducted later that morning around 9 a.m. when visibility had improved. That 9 a.m. entry was determined to be a continuation of the initial investigation begun by crews at the scene, and a warrant was not required. The cases Bennett versus Commonwealth in Virginia and State versus Vader in New Jersey are almost identical. In each case, there was a fire in the home of the defendant, and the authorities, immediately suspecting arson, organized an investigation by an expert after each fire had been extinguished. In neither case was a search warrant obtained, nor was there a finding that consent had been given to search the home. As a result of these searches, each party was charged with arson. In Bennett, the defendant was convicted after a motion to suppress the evidence had been denied at the trial level. This conviction was affirmed by the Virginia Supreme Court. In Vader, a motion to suppress evidence was granted by the trial court, but an intermediate New Jersey appellate court reversed the order and remanded the case for trial. Additionally, Your Honor, no homeowner was at the premises at the time of the arrival of fire investigators at 614 Mays Street. Considering the recent departure of fire crews and the unknown time of the return of the homeowners, it should be considered reasonable for the investigators to begin their investigation into the Mays Street fire and the evidence documented and collected, such as this photograph, which shows a pour pattern on the floor behind where the television had been located in the living room, should be admissible in this trial.